and welcome back. You're listening to Passing the Baton. I'm Jared Hight from Tracktown Law, and today we're diving into one of the most deceptively simple corners of estate planning: beneficiary designations and non-probate transfers. We're talking about things like POD, payable-on-death bank accounts, TOD, transfer-on-death deeds, and the little boxes you check when you open an IRA or buy life insurance that say, name your beneficiary. They sound easy, and they are. Too easy sometimes. A quick disclaimer: I'm a licensed attorney in Oregon and Idaho. This podcast is for educational purposes only. It does not create an attorney-client relationship, and it is not a substitute for legal advice. If you want a plan that fits your life, let's talk. Let's start with what these tools are designed to do: bypass probate. If you name a beneficiary on an account or asset, that asset goes directly to the named person at your death. No court, no waiting, no public record. It's automatic, it's clean, it's efficient. Until it isn't. Because while non-probate transfers can streamline things when used properly, they can also create chaos when used carelessly. And once the asset transfers, there's no court oversight to fix it. Let's go through a few common examples. POD accounts. Most banks and credit unions let you add a payable-on-death designation to your checking, savings, or CD accounts. When you die, the funds go to the named beneficiary. Done. Simple. The problem? People forget they did it. Or worse, forget to update it. I've seen ex-spouses named as POD beneficiaries on accounts a decade after the divorce. Unlike a will, or Oregon law automatically revokes gifts to ex-spouses, POD designations don't auto-update. The bank doesn't ask for your divorce decree, they just follow the form on file. TOD brokerage accounts. These work like PODs, but for stocks and mutual funds. You can name one or more beneficiaries to receive the account directly, but the same rules apply. Whoever is on file gets the assets, not who you meant to name, not who your will says. The form wins. Life insurance and retirement accounts. Same story. You name a beneficiary, and the company pays them directly. If you name your estate by accident, or leave it blank, the proceeds may have to go through probate. That delays payout and may expose the funds to creditors, estate tax, or court supervision, especially if your heirs are minors. Now, TOD deeds are a special creature. Oregon allows a transfer-on-death deed for real estate. You sign it, record it with the county clerk, and it takes effect only upon your death. No probate required, but it has to be recorded while you're alive. Stash it in a drawer and forget, it does nothing. And if you refinance or retitle the property later and forget to re-record the TOD deed, you've accidentally revoked it. That's not a bug, it's the law. Here's where things get dicey. Non-probate transfers don't coordinate well with complex family situations. Let's say you have 3 children, and a will that leaves everything equally among them. But you also have one POD account with only the eldest named. At death, that account passes entirely to the eldest child, even if your will says otherwise. You may have just disinherited 2 of your kids. Not because you wanted to, just because that account didn't follow the same rules. The law treats non-probate transfers as separate and superior to your will. That means they take priority, no matter what your broader plan says. This is where estate plans start to break, not from malice, but from mismatched paperwork. Now let's talk about timing. These transfers happen instantly. The funds, title, or shares move before anyone inventories the estate. That might sound great, unless the estate owes taxes, final expenses, or debts. If 90% of the decedent's money flowed directly to a single beneficiary, the personal representative is left to scrape together cash to cover the bills, sometimes by asking beneficiaries to give money back. You can imagine how well that goes. Also worth noting, if a beneficiary dies before you and you don't update the designation, that account may default back to your estate or pass to unintended heirs, depending on the financial institution's terms. Some allow contingent beneficiaries, some don't. It certainly pays to ask. Now, are these tools bad? No, not at all. They're very good when they're used on purpose. They work best when integrated into your estate plan, not tacked onto the side like a bonus feature. Here are a few best practices. Name both primary and contingent beneficiaries. Always. Assume life will throw a curveball. Review your designations every 2 to 3 years or after major life events, marriage, divorce, births, deaths, moving states. Coordinate with your will or trust. If your estate plan says divide equally among children, your account titles and beneficiary forms should mirror that. Avoid naming minors directly. Use a trust or custodial arrangement. A 6-year-old can't legally own assets, and the court will step in if you don't. Use TOD deeds carefully. They're powerful, but fragile. Review them when you refinance or update your trust. In short, don't let the easy button backfire. Non-probate transfers are like power tools, incredibly effective when used correctly, but surprisingly dangerous when you skip the instructions. They should simplify your estate, not sabotage it. Want help reviewing your beneficiary designations or integrating them with a proper will or trust? Visit tracktownlaw.com. I'll walk you through the alignment process and make sure everything points to the right people in the right way at the right time. Next episode, we'll talk about Oregon's transfer on death deed in more depth, how to draft it, record it, and avoid the common pitfalls that turn a great shortcut into a dead end.